Hey everybody, this is Eugene Leisha here. Welcome to episode 16 of Forensics Talks. This is our first episode of 2021, and as of last year, we had some really good success with these talks. So I've decided to continue them on and have some fun with them. I think they went really well. We had some really great feedback, and so I want to say thank you to all the people who have been watching and sending me emails and providing comments and all that sort of thing. So thank you very much. I also want to welcome the class from the NCIS. They're doing some laser scanner training with their instructor, Jason Keller, and they're actually going to be using today as, I believe, part of their training. So they're going to be watching, which I think is absolutely great. So yeah, thank you for that, Jason. A couple of announcements that I have. I'm just going to bring them up here before we get started. And that is that I have a bullet impact study that I announced some weeks ago, and I'm going to be cutting it off next week on the 15th. And I've had some really great response, but I just want you to know that there is still time to participate if you are interested. So if you are, just go to my website, AI23D, and go to the research page. And once you get there, you'll see that there's a page here where you can sign up. Once you register, you'll get an email back with a video with instructions and that sort of thing. So by all means, if you can, please jump on in there. Also, there's a couple of conferences coming up, and I know some of you are interested. Last year, I was at the Association for Crime Scene Reconstruction Conference, and it was a really great conference. Some really, really good people, really, really excellent presentations. So if you are interested, just head over to the ACER site, acer.org. This year, it's March 2nd to 4th, I believe. And it is going to be a mix. So it's going to be virtual and somewhat in person. And in addition to that, there is also the American Academy Conference, which is coming up. And I know some of you are interested in that one. That's February 15th to 19th. And my understanding is at this point, it's pretty much their first virtual conference. So by all means, just keep that in mind. So for today, I'd like to introduce our speaker. That's Jonathan Hack, and he is a barrister and solicitor with over 30 years as a Crown prosecutor with the Alberta Crown Prosecution Service in Calgary, Alberta. He's been prosecuting major crimes, and he specializes in legal issues involving expert evidence, expert witnesses, and digital multimedia evidence, which is in particular of interest to us today. He's appointed the Queen's Counsel in 2006, and he teaches law in North America, the United Kingdom, Singapore, Hong Kong, and his courses are actually quite popular. So he teaches two courses in particular, which I know are of interest, and I know some of the people watching today probably have taken his course already. One is courtroom testimony for expert witnesses, and the other one is courtroom testimony for investigators. He teaches, and I don't know if primarily he teaches this for the Law Enforcement and Emergency Services Video Association, or LIVA, but that's where I first heard of Jonathan. He holds a diploma in criminal justice from Mount Royal University in Calgary, Bachelor of Science degree in criminal justice from California State University, law degree from the University of British Columbia in Vancouver, and a Master of Law degree from the University of Cambridge in England. And if that's not enough, Jonathan is working on his PhD, so he's a PhD candidate in the faculty of Leiden in the Netherlands. He was living in the Netherlands for a short time, but he's back in Canada, in Calgary. So I'm going to bring him in here. Hey, Jonathan, thank you so much for being here today.
Thanks, Will. Thanks very much. Happy to be here, Eugene.
Excellent. Well, first things first, I want to ask you about your background and how you first got into law, and what was that little trigger that went off in your head that said, that's the direction I'm going?
Well, it's an interesting question. When I went to university for my first degree, it had been my plan to be a police officer. And I suffered a farming accident during my third year of university. And that result of that meant that I couldn't go into police work anymore. And so I thought, if I can't do that, what's the next logical thing? And that's when I thought being a prosecutor was the next logical extension. And so that's what caused me to go to law school after my bachelor's degree, and certainly not something I regret.
Yeah, for sure. And so you were 30 years in Alberta as a prosecutor. And so you had quite, trying a heck of a lot of different cases and seeing a lot of different things. So I'm going to definitely ask you about some of these, because I'm sure you've seen some crazy things over your career. What about the fact that you focused on or have an interest in digital evidence, digital multimedia evidence? When did that first come about?
Yeah, that actually came out of a homicide prosecution that I did in 1999 and 2000. It was a case that involved video evidence, and the video evidence was quite central in that case. And so I retained a forensic video analyst from the Vancouver Police Department, and it was that that got me interested in forensic video analysis and ultimately in digital media overall. So that was about 10, 12 years into my career. And it really took off from there. And I ended up being heavily involved in digital evidence for the balance of my career and post my Crown career as well.
And in terms of LIVA, when did you first get involved with them?
So LIVA, the Law Enforcement and Emergency Services Video Association, started their training in July of 2000, and that's when I started. For the first 5 years, we did all our training at the FBI Academy in Quantico, and so I was involved with Grant Fredericks in developing the LIVA training curriculum, and what I brought to the LIVA courses and continue to bring to the LIVA courses is all of the legal content, understanding the legal basis for video evidence in criminal prosecutions, forensic video analysis, legal issues, authentication issues. So I teach those aspects in all of the LIVA courses, and I'm usually involved in a lot of the LIVA conferences as well. So that's when I got involved.
Okay, and well, I think we'll probably let's just jump into it, because I think the two big things here, and you're very well known for your courses, and I think that's where a lot of people who have talked to me about you have said, hey, you gotta, talk to Jonathan about his course or whatever. And they talk about the stress that they go through in the course, especially at the end with the mock court or I think that's maybe something that a lot of people don't expect. But in terms of the courses, well, first of all, how long are they? Are they like a few days, or are they a couple of days, or?
So the two courses that I've developed, aside from LIVA, courtroom testimony for expert witnesses and courtroom testimony for investigators, the expert witness course is a 3-day course. The investigator's course is either a 2 or a 3-day course. The next expert witness course is actually January 18th. So that's a 3-day course, and that one has people from across North America attending.
Okay. And in terms of the content, what kinds of things do you really hit on, or what are the main focuses for the expert witness course? Like, if you could give us kind of a brief outline.
Sure. So what I focus on is this, that we spend an awful lot of time training people how to be experts in whatever their area of expertise, it doesn't matter. But we spend very little time training them how to be an effective communicator in the courtroom. And one of the points that I make in my courses is that no matter how brilliant you are, if you can't take that brilliance and operate effectively within the courtroom, then we lose the benefit of your brilliance. So in the courses that I teach, I work on that skill set. We look at drafting expert reports and curriculum vitae. We look at the steps that are involved in preparing for trial procedure itself, and then we take a pretty deep dive into developing skills to be an effective communicator in direct examination and in cross-examination, learning about common cross-examination techniques and how to not only survive them, but to actually profit from them so that your evidence is even better at the end of cross-examination. And to put that into practice, I have typically 8 moot courts during the 3-day course, where we go through the qualification process to become an expert, and then substantive moot courts on expert reports that participants submit. And so these are courses that I do for LIVA, but I also do quite a few of them just on contract to various police agencies or forensic labs or other government organizations, private law firms, that sort of thing.
Okay. As a prosecutor, I was just imagining, over such a long career that you've had, in dealing with so many different experts, and having people understand. You must have your top 10 list of the greatest expert witnesses you've ever had on the stand, and the 10 worst. So I'm curious about the worst and some of the mistakes that they've made or what they could have done better.
Yeah, and it's interesting. As a prosecutor, I've led forensic expert evidence hundreds and hundreds of times in many, many different areas of expertise, and have cross-examined many experts called by the defense. And there are some that are just a dream to watch testify. They're so good. They're masterful speakers. And then there are some experts that are understandably very nervous, don't handle cross-examination well, give in too easy. And it's that lack of familiarity with the public speaking aspect of being a forensic expert that I really focus on in my course, because that really is the challenge. And yes, I've seen amazing experts. I've never seen any terrible experts, but I've certainly seen experts that could learn a lot on how to be an expert witness. Interestingly, Eugene, one of the most common comments I get from people who take those two courses in particular is that they wish they had taken it earlier in their career. It's never too early to learn the skills that are necessary to be masterful in court. And you can be masterful in court. It is a skill set that you can study, you can practice, and you can put into place.
Yeah, sure. That makes a lot of sense. And I mean, you're working with LIVA or talking about digital multimedia. I think it makes sense that there may be some aspects, and I want to ask you about maybe some of the things which are more specific to the digital multimedia side. But of course, a lot of what you're teaching applies right across the board, regardless of the type of expert witness that you are or your discipline, I would imagine. So let me ask you that question next. And in speaking about video, photographs, and that type of evidence, what kinds of things or what kind of considerations should an expert witness be looking at for that particular area?
Well, one of the most important things, and though it may seem obvious, it needs to be stated, is you have to truly be an expert. You really need to know the science. You need to know the basis of video images, and you have to understand the software that's involved, the processing that you do, the correct forensic process. So that's number one. You have to know what you're doing. You have to have that level of competence. Then we look at your ability to effectively present that evidence visually. How are you going to visually present the evidence? Are you going to use timelines? If so, are you going to use a proper timeline? If you're going to be comparing question to known images, do you have the necessary knowledge to do that? And are you showing them in a correct way such that a judge will allow them? Because there are cases in Canada and America where judges have said, nope, I'm not going to let you show it the way you want to show it. And then you have to have the ability to communicate. So it's competence, it's an effective visual presentation, and then an effective oral presentation are the three global components that a digital video expert or digital media expert needs to be that effective expert witness.
So things like obviously training, making sure that you have some kind of training or several regularly going out to conferences, being updated. If you have any publications or research, things like that. What other things lend themselves to credibility as an expert?
It's certainly all of those things. We're really looking at the whole package. We look at a witness's collective education, training, skill, and experience. And so we look at university courses, if you have them. We look at specific training. We look at background. A lot of people have a production video background, which is perfectly fine, but you need forensic training. You can't just switch from forensic or from production to forensic. We're looking for that training. We're looking for certification. We're looking for practical experience and that forensic mindset. One of the things that I've seen over the years is, I guess what I would call is a lack of a forensic mindset in some people that are doing this work, because this actually is science. It isn't just putting on a show and doing a matching exercise. That ability to utilize that scientific mind and the scientific process is clear, because the reason we're calling you to testify is because of the science that you're presenting, not just the cool images that you're showing. So that underpinning in science is critical.
Yeah, no, I think that makes a lot of sense. You have I want to point this out to people, because you actually have a blog here. Let me just share the screen here. But for those of you that don't know Jonathan or whatever, yeah, try to get to his website. He's got a blog, and he actually has some really interesting articles there that I think can be useful for people. And most recently, there was one published about 3D data or 3D evidence, and I want to definitely speak to you regarding that too. There are some. There's definitely some similarities with 3D evidence and, obviously the other types of digital evidence. And with the advent of photogrammetry, 3D laser scanning, hand scanning, there's a lot of different types of 3D data. Do you find any differences or any similarities between, a lot of people that are working in video and, people that are doing other types of digital evidence like the 3D stuff?
Yeah, the challenges are largely the same. We're looking at the authentication of the data that you're relying upon for your analysis. We're looking at the proper presentation of that so that what we're seeing is fair and accurate. The case law that is out there in Canada and the United States is very similar, and it really focuses on authentication, accuracy, and the fairness of the presentation. So the parallels are clear. It's simply a different application. We're looking at three-dimensional imagery rather than two-dimensional imagery, but the application is a parallel.
Yeah, for sure. And I thought the article that you did was really great. In fact, I'm going to put that into the window here for people to see. I'm going to see if I can put that link in there. But I thought that was very well done. You did an article recently, and actually, well, why don't I ask you about it, the 3D article, and because you obviously did some research, you looked at cases, you looked at some different aspects. So what can you tell us about the blog post?
Sure. So I and along with yourself, as I discovered after I got involved, are involved in the terrestrial laser scanning working group that is involved in the US in putting together proper guidelines and recommendations for the use of terrestrial laser scanning in criminal justice. And so what I was asked to do, and the purpose of my research, was to look at the legal considerations involved in using TLS evidence in the criminal justice world. And so I focused solely on the United States, solely on US case law, because that was what I was asked to cover. And it's quite interesting looking at the cases. Most of the cases are actually civil cases, not criminal cases, but I've written about both of them. And the challenges that have been identified by the courts are, again, common challenges, whether the data is authentic, whether it's used correctly, whether the operator, the analyst, is overdriving the evidence. So they're very interesting. It's a very interesting subject. What I've done on my website is I've covered really three different topics: forensic video analysis or video issues, expert witness testimony issues, and then visualization of evidence issues. So looking at those three different things written for people in the forensic community in all disciplines from an expert witness testimony perspective, and then more focused on video and more recently 3D laser scanning.
Yeah, it's interesting. This whole 3D laser scanning area, and I just mean actually not even laser scanning, but photogrammetry, all these other, just anything that's 3D is a little more difficult now, because it's not like there is an organization called the International Association of Forensic and Security Metrology. And so that's a group that's wanting to get to a point like LIVA, where they have certification courses and things like that, but they're not there yet. And so in the interim, there's sort of different levels of people using this technology. There's people that, maybe some people are excellent. They have a lot of knowledge, very, very well informed. And there's some people that are just, people that press buttons, sometimes, or just, the technology people. So there can be quite a bit of disparity between the different groups of people. And so I'm trying to think of now, is there a risk for some people getting to court and then being judged as not having enough qualifications because of where we are, but then again, they don't have many options because there's nowhere to go.
Yeah, you raise an important concern, and the case law is pretty clear that there is a distinction between someone who knows how to do it, the technician, and someone who knows how to analyze the data. And so in law, we often categorize those people differently, where a technician might be brought in as a fact witness or a technical witness, but not qualified as an expert witness because they're not giving opinions. And then we might rely on an analyst to actually analyze the data that the technician collected. And from that expert, we will then look for opinions on height, location, dimensions, that sort of thing. And so there is a distinction between the technical person, the technician, and the analyst. In some cases, one person does both. In other cases, you've actually got two different people, one who collects the data, one who analyzes the data. And the law is pretty clear that in order to give expert evidence, you need to actually know how these things work. It isn't enough to use the term, a button pusher.
Right. Have you ever been in a situation where a defense attorney or whatever is actually attacking the technology or the science, right? So somebody's going, well, no, we're gonna go after the technology of forensic video analysis or something like that. Have you ever run into that situation?
Yeah, absolutely. When the Calgary Police Service switched to total stations system back in the late 90s, there was a bit of a challenge there, and I was involved in getting those into court, where we switched from hand measuring scenes to scanning scenes. So there was a challenge there, but yes, I've certainly had challenges there, and I've had ample challenges on video-related issues, the science behind comparison work, the science behind doing image clarification, reverse projection, that sort of thing. My experience has been that the defense lawyers who I have encountered have asked good questions, but they haven't had an expert working with them. And so they've asked the questions as best they can from their own research, but they haven't had the benefit of an expert working with them as a defense consultant, because there aren't that very many people in private industry in North America doing this work. Most of the people that do forensic work are typically associated with an investigative or a law enforcement agency.
Yeah, that's a good point. One of the cases that you listed in your blog post on the 3D data was one that I actually worked on, and I can tell you that when I walked in that case, I was working for the defense, but the prosecutor pretty much came up to me and said, "I have no idea what you're going to be talking about. I don't know, whatever." And I said, "That's okay. Like, I'll explain it as best as I can, as simply, as a simple, easy language as best I can." But I think it's true. There's a lot of education that needs to happen, not only for the expert witnesses, but for counsel as well.
Yeah, you're absolutely true. I think the reality is that most lawyers don't have a background in science, don't understand technical things anywhere near as good as an expert, because if we did, we wouldn't be lawyers, we would be doing something else. So I'm certainly one of those people that I'm certainly not a technical expert, but I really enjoy working in the forensic sciences. And so that is a challenge that lawyers have, is they can ask the questions as best they can, but without an expert assisting them, they run out of questions quickly because they don't have the scientific background to keep going and to evaluate the answers that they're getting from the witness on the stand. And so your question about your example of the prosecutor saying, "I don't really know what you're talking about," is so common. It shouldn't be, but it is very common.
Yeah, fair enough. And I mean, we were kind of chatting before, like in order to ask questions or good questions, you need to know something about the topic that you're discussing, right? It's difficult, and I know that oftentimes, both on the prosecution and defense side, the people are like dealing with massive amounts of information, so they're always trying to play catch up, trying to get caught up on papers and reading and stuff. So I can understand how that can happen.
Well, and
Yeah.
they are, and if I may just add, Eugene, in most of the serious cases that I had as a prosecutor, I would typically have 5 or 6 different areas of forensic expertise involved. They're all murder prosecutions. And so I learn as much as I can so that I can ask intelligent questions, understand the evidence that's being led, but I'll never rise to the level of the expert witness that's there, nor do I need to as a prosecutor. I need to be able to ask questions, understand the answers, and go from there. But oftentimes we're dealing with a half a dozen different areas of expertise. We're not going to know all of those to a great level, but we need to know them to a level of competence that we can use that evidence effectively.
Yeah, that makes sense. I had a question that I want to ask you about as an expert witness and being on the stand. What kinds of things can an expert witness do when they're being treated aggressively? Let's put it that way. You have an aggressive cross-examination, and it's starting to get heated. What kinds of recommendations do you have for an expert witness there?
Sure. One of the temptations when cross-examination gets aggressive is for the expert witness to be defensive because they are being attacked. And so it's natural to be defensive. And when expert witnesses are defensive, they tend to do poorly in their responses because now it's personal. And so they tend to not take enough time to think about the question, think about a proper answer. They tend to rise to the same level of discourse as the cross-examining attorney. They might become sarcastic, give grudging answers, admit something, but admit it in a way that is very petulant. There are specific techniques that can be used to diffuse a lot of questions that are posed in cross-examination. And those are techniques that I teach in my course. They're techniques like using negative assertions effectively and the admit-deny technique. And those are techniques that put an expert witness in the position that not only will they have answered the question, they'll have re-emphasized the evidence they've already given in direct examination. And when witnesses are able to master those questions in cross-examination and profit from them, what they're going to find is they're going to get decreasing amounts of questions after that because they've shown that they can handle them well. And in fact, that every question only makes their evidence better. And that is all part of preparation, training, and practice. One of the challenges that witnesses have is that they are reactive and not proactive. An expert witness should have a plan for their testimony, not just a plan for their content, but how they're going to present it, what exhibits they're going to use, what things they're going to show, what questions they want to be asked. And they have a plan for how they're going to handle that cross-examination question if it comes up. So being a proactive witness is critical. The default is to be a reactive witness and you just answer whatever comes to you. Being a proactive witness is so much better. And then you'll actually, oddly enough, enjoy cross-examination and you'll be keen to go another time.
That's funny. I'm not sure if I'll ever enjoy cross-examination, but maybe one day. I have a question. So I was just thinking, how can I phrase this? If, as an expert witness, when you're on the stand, sometimes there may be something on your mind or you feel something is important, but you may not be asked that question directly, but it may be important for the jurors to understand, or it may be important for clarification. How much power, or I don't say power, but how much leeway does an expert witness have, to be able to say, look, I feel like I need to say something?
Yeah, that's a really good question. Expert witnesses, their sole role in court is to answer questions, not give speeches or talks. And that's tough, because it would not be correct for an expert witness to say, by the way, no one asked me about this, but I'd like to tell you a few things. You'll get shut down right away, because that's completely improper. So what the expert witness needs to do, this is part of being a proactive witness, not a reactive witness. If there are things that an expert witness needs to get out, it's important that it come out. That needs to be planned in advance with the prosecutor or the defense lawyer, whoever's calling you to the stand. Make sure you ask me about these 10 things, because I need to talk about them. If that doesn't happen, then what the expert witness has to do is look for a question that can be the inroad into that particular topic. And that's the best way to get there, those two methods, planning for it in advance or looking for that inroad. But an expert witness isn't entitled just to change the topic and talk about something that they're interested in, because they'll get shut down right away. It's completely improper. Your job is to answer questions, not give speeches.
Yeah, so look for the open door, or find a way to steer things a certain way, and and then take advantage of that opportunity to say what you have to say.
Yeah, and the more comfortable you are on the witness stand, the more comfortable you'll be at finding that inroad, and it won't seem as awkward as it might otherwise be.
Mm-hmm. There was I don't remember exactly where I read it, but it was something that you had that had to do with mistakes. And there was a very interesting talk I had with somebody last year. His name's Dr. Itil Dror, and he's like a cognitive scientist. He deals with bias and that sort of thing. And one of the things he said, which really struck me, was he can go to a medical conference and ask the question, how many of you here, how many of the doctors here have ever made a decision that could have costed a patient's life or caused problems, whatever, and hands go up. You go to a forensics conference and ask, how many people have ever possibly made a mistake, that might have cost somebody, the prison time or whatever. No hands ever go up. Nobody wants to admit that they can make a mistake. And I thought that was really, I believe that there's some truth in that, and that forensic experts are always, we got to be right every time. And so when there is a mistake that's made, or something is found and it's an oversight or whatever it might be, what's the best way for an expert witness to handle something like that?
And are you talking about a mistake made on the witness stand, or a mistake made in the work that resulted in the expert report?
I think more the bigger for me is, if you just make a mistake saying something on the stand, that's not as bad. You can always clarify or whatever. But I'm talking about, like, what if there's an error in your work, or something that you're up there on the stand, and all of a sudden it's like you have an oh crap moment. Sure. How do you deal with that?
Well, a couple of things. First of all, an expert should never be in the position that on the witness stand they discover the error. All of the work that they do into doing the analysis, doing the scientific research, writing the report, should eliminate that. And if that doesn't, the peer reviewing should for sure eliminate the need for a report to ever be issued that would have a significant error. But let's say that the expert, for the very first time, has a significant error pointed out on the witness stand. They first have to determine whether this really is an error, because sometimes under pressure of the bright lights on the witness stand, counsel will point out something that appears to be an error, which in fact isn't, but the expert is too nervous to appreciate how to handle that. That's a challenge. You need to think about the question, think about the answer, give an informed response. It would be a mistake to capitulate right away and say, you got me, without really evaluating that. I think what a witness would want to do, if a witness was posed with what looks like an error in their testimony, and they need a moment to think about it, frankly, is to turn to the judge and say, Your Honor, might I have a few minutes to consider counsel's questions? The judge may or may not allow that. You can't talk to anyone if you get a 5-minute break, but you can think about the question and come back and give an answer if you're allowed to do that. Otherwise, you'll have to deal with it under pressure. But the key is to determine if it really is an error. If it is an error and you realize that that's happened, you've got to own up to it, and you're going to have to think on your feet. I had a case one time where I caught a forensic expert on the witness stand in cross-examination with an error. It was a fundamental error that totally devalued the evidence of the opposing expert, and she had no choice but to say, my opinion is of no value anymore because of this fundamental error. That's very, very rare. Doing all of the work up front, doing that peer review, doing that preparation, which is so important, should place an expert in the position that they're never finding themselves having any substantive error discovered. But that's what you'd have to do. You have to deal with it. You can't just say, I choose not to answer that question. You can't plead the fifth when you're an expert.
Right. Yeah, that makes sense. And then, well, let's talk about the, just a mistake on the stand where you misspeak or whatever. I do it all the time. I just, my mind's in, 5 different places, and then, you think you're saying one number, but another number comes out, whatever. You think you said it correctly, but you did not, right? So in those cases, is there recourse there to correct? I mean, sometimes counsel will help, no?
Yeah, there is. There's a couple of different options. If you've just made the error a moment or two ago, then you can simply turn to the judge and say, Your Honor, I just realized that a couple of minutes ago I said the answer is X. I was in error. The answer is Y. The judge will allow you to correct that. No problem. You don't need to tell the lawyers. Just talk to the judge. Okay. If it's half an hour later, an hour later, or on a completely new topic, and you realize, whoops, I screwed up an hour ago, again, you don't talk to the lawyers. You would turn to the judge and you would say, Your Honor, I just realized now that when we were talking about X, I might have made an error in my testimony. Might I be given the opportunity to correct it? If the judge says, yes, go ahead, then you can correct it right then. Sometimes the judge will say, well, I'm going to leave that up to counsel. And that's all you have to do, because by you alerting the lawyers to that, if the lawyer asking you the questions doesn't immediately go into that topic, then the other lawyer will for sure. But the most important thing is tell us that you've made the error, but don't tell the lawyers. Always turn to the judge and tell the judge that you've made an error. If you just made it, fix it. If it was a while ago, ask for permission to fix it. You're going to get to fix it either then or later. That's what redirect examination is for.
Okay, great. I want to respond to some of the comments that are coming up on YouTube here, and one of them is you had talked about visualization being very important, and one of the benefits of dealing with digital evidence is that a lot of it is visual, especially on the 3D side these days with panoramic images and 3D data, photogrammetry. And presenting that it's super helpful when people can actually see, a picture or a 3D model. But what about have you given any consideration to virtual reality and the possibility in the future that people, are not just going to watch something on a screen, but then maybe even, stick a set of goggles on and then look around? Have you ever thought about what might be some of the challenges or whatever there?
Yeah, it's one of the areas that I'm working on in my PhD. I'm doing a PhD in law at Leiden University in the Netherlands, and my PhD is on the use of non-textual or visual evidence in atrocity crime prosecutions. So I'm focusing on genocide, crimes against humanity, crimes of aggression, and war crimes prosecutions, but all of that work applies to domestic cases as well. One of the chapters in my PhD is on virtual reality, immersive reality, and we're starting to see that being used internationally and domestically as well. So it is one of the areas that I'm working on. It's not the chapter I'm working on right now. Right now I'm working on using different methods of visual evidence as a didactic tool, as a teaching tool, and also as a method of proof. But it is one of the topics that I'm covering, and that's why, at least I think, the topic that I've chosen for my PhD is extremely interesting.
Yeah, no, for sure. And how far along are you in the PhD?
I'm, I'd say, about halfway through.
About halfway through. Okay. And are you going to be giving more treatment to the virtual reality stuff then? I mean, at some point in the future, or
Yes.
actually, I'll have to speak to you after because I actually have a little project going on where it may fall right in line with your PhD. So maybe we can talk about that afterwards.
Sounds good.
Yeah. I'm just thinking about the jury and communication to the jury. Somebody once told me that the most important thing that you can do on the stand is to communicate directly with the jury. So, like, look at them, make eye contact, make sure that they understand what it is that you're saying. And sometimes, and I do that now. So I have a habit where if I'm asked a question, I try to turn and look to the jury and try to explain it to them. And I think I always say that the most important thing for me is if I see them going like this, then I'm like, okay, I think they understand, and then that's important. But any other suggestions there for speaking, and who you looking at the judge, looking at who do you look at and who you're
Sure.
communicating to?
Yeah, I loved jury trials. I did many jury trials, and one of the most interesting parts of a jury trial is taking complex forensic science and with your expert explaining it to 12 people who have only seen the hint of this on television. In my courtroom testimony for expert witnesses course, I teach that about 2/3 of an expert witness's time should be spent looking at the jury, teaching them, because as an expert witness, you're not just giving evidence, you're teaching 12 people, plus the judge and the lawyers, about your area of science, the work you've done in this case, and the opinions that you've arrived at. And by looking at the people who have to evaluate your testimony, these are the people who are going to grade you. They're not going to put up a sign holding a pen, but they're going to grade you at the end when they give their verdict. Looking at them will give you that feedback. You gave a good example of that, Eugene. I call that the nod test. I always looked for jurors that would nod. And in my experience, there are usually 3 or 4 unofficially designated nodders on a jury that will nod when they understand the evidence being presented. And so a witness would want to look at the jury, scan all of them, but look for the nodders. And if the nodders are no longer nodding, chances are you've left them behind. The lawyers should always be looking. I would always look at the jury as well. I'd spend half my time looking at the expert, half my time looking at the jury, and I'm looking for signs of confusion. And then that's an opportunity for the witness or for the lawyer to say, maybe I could explain that a different way. And then you're looking for that nod again. That nonverbal communication is so valuable. And you've got to look at the 12 people that are ultimately grading your evidence. That's the class that you're teaching. And you ignore them at your peril, and you look at them for the benefit of your case and for the benefit of your testimony. And it's a fascinating dynamic.
Yeah, that's very interesting, and I wish I'm glad I was told that little tip, and I feel that it's helped me quite a bit. Just that a few little things make a big difference. I had mentioned before about Dr. Itiel Dror and about bias, and I'm wondering, in your experience, how much of a factor that's been at some trials. Whether it's been the expert that works for the police or the defense expert, whatever it might be, and not in particular with digital evidence, but just in general. Have you found it to be a major factor?
Yes, it is an issue. I read, Itel wrote an excellent article in 2020 on bias in forensic science, a fascinating article, and I've been in communication with him about that. Yes, it is clearly an issue. I would say, Eugene, that bias is probably one of the most important topics in North America in the forensic expert world, because we have a problem with experts who don't understand what their role is. There are so many experts who don't understand that they don't work for the prosecution. They don't work for the defense. Their sole duty is to the court to provide honest, objective, impartial evidence. Whether it helps one side or the other, that's ultimately for the trier of fact to decide. But bias is absolutely a hot button topic, and so it should be. In my experience, I've dealt with, I couldn't even guess how many hundreds of expert witnesses during my career, and I've come across very few experts that I thought were particularly biased for the prosecution or particularly biased for the defense. So my experience has been generally quite favorable, but I have come across expert witnesses who did display a bias. And a biased witness, what they're really doing is they're holding up a flag and they're saying, go after me, challenge me, because you can challenge a biased witness and raise that bias. And then we get off topic and then we start looking at bias, anything other than the evidence you're actually presenting. So bias is a significant issue. And for expert witnesses who tend to only testify for, say, the prosecution, they have to be mindful that they're there to assist the court. They're not the prosecution's expert, even though they're being called by the prosecution.
Yeah, I thought there was a really good example for me personally. There was a case that I worked on. It was officer-involved shooting here in Toronto, and I did a 3D reconstruction. But we had actually met before trial with the defense, and we had looked at all the materials. And while at trial and on the stand, it was nice to see both sides using the materials equally to say, how far would it be if somebody was here or there, or where different people move, different positions, different viewpoints. And I thought that to me was a testament that not really more about me, but even just the fact that the data can be used objectively when you're talking about digital evidence.
Yeah, and that's the way it should be, because the evidence is the evidence. And if it helps one side more than the other, well, that's nice. But the idea is that it should be there for everyone's benefit. And irrespective of who you're testifying for, who's called you to the stand, you should be there to help everyone. And that should also be your attitude in cross-examination. You shouldn't view it as a fight. And I'm going to really show this defense attorney, for example, what for. You should be there to be of assistance. And boy, will you score points with the court when you show that you are there to help everyone, not just the side that brought you to the dance.
Yeah, no kidding. That makes a lot of sense. Hey, what's the difference between the expert witness course and the course for investigators? What kinds of things do you treat differently there?
Sure. So the expert witness testimony course focuses on experts in any area of expertise. A class will typically have half a dozen different areas of expertise in it. And the focus is on writing reports, drafting CVs, preparation for court, and then the dynamics of direct examination and cross-examination. In the investigators course, we don't look at curriculum vitae. We don't look at expert witness bias. The focus is on investigative reports, investigative notes, but there's probably about a 60% overlap between the two courses, because the courtroom, the witness stand skills are largely the same whether you're an investigator or an expert witness. The one difference being the investigator is much more constrained in their ability to give opinions. So it's the kind of thing that you would only take one course. There would be limited value in taking both. I have people that ask if they should take both, and I always say no, pick the one that best suits the work you're doing, and that's where you'll get the most value.
Yeah, okay. There's a question here from Phil Boyd. Hey, Phil. He talks about any suggestions on awareness, like when you're at court, like how to demonstrate that you are aware of bias from the expert witness.
Absolutely. This is something that is wise to deal with up front. What an expert witness wants to do is, through their testimony, make it clear that they have approached the case objectively, that they haven't gone into the case with a preconceived notion of what the solution is. They've looked at all of the data. And if they're asked on the witness stand a question, isn't it true you always testify for one side? Assuming this is true, you want to deal with that head on by not telling the lawyers, but turning to the judge or turning to the jury and saying, members of the jury, it's because of what counsel is suggesting that I'm so careful in my work to ensure that I've objectively analyzed the data, because my job is to be objective and impartial and to assist you. And so it's something that I think you need to deal with head on. You deal with that by the way that you do your work, by considering all of the applicable theories. Don't have an agenda. Don't be trying to get to a specific conclusion. So you'll prove by your work that you're objective. And in your testimony, in the way you give your evidence, you can bolster that objectivity as well.
Okay. Do you have any plans for making a course on bias? I don't know if you've thought about it, or if you have something, or.
I don't have any specific plans. I do spend a reasonable amount of time talking about that in the expert witness testimony course, and in one of the LIVA classes, forensic video analysis in the law. I do a 2-hour section on bias there, but I haven't considered a standalone course. My plate's pretty full right now.
Okay, yeah, I understand. We're getting on in time, but I have one more question, and that has to do with what's next for Jonathan Hack. I know you have the PhD, but research, or are there any future directions that you'd like to go and study, or things that you want to do?
It's really the PhD. The PhD, in addition to the teaching that I do for a university here in Alberta and for LIVA and for my own company, in addition to the teaching, the PhD is my full-time work, and I'm trying to get that done within the next year or so, and then from that, hopefully publish a book on these topics.
Okay, nice. Yeah, that'd be pretty good. And so you think it's going to be a couple of years, maybe?
I'm hopeful that within the next year or so, I will be able to see the end.
Okay. Well, I'll tell you what, I want to just remind people, I'm going to bring up your page here before we go, because I'd like to see if I can find the page where you've got the courses. Is that on the homepage? Let's just see here.
There's a tab, I believe, called courses at the top.
Right. Contact and course hosting?
That's perhaps the one.
That's the one there. And I just want to see. Oh yeah, courtroom test. So there's some dates there. So if anybody's interested, go to jonathanhack.com. And you said the next course was coming up.
January 18 to 20 is the next courtroom testimony for expert witnesses course. Right now, we've got people from various places in Canada and the US. And people might find the website helpful just for information. They can subscribe to the website. They don't get a free blender or anything. All it means is that when I publish a new article, it gets sent to them. And I publish at least once a month. Okay,
that's great. Well, Jonathan, I want to say thank you so much for being here today. You're number one in 2021 here for me, so I really appreciate it. I know this whole COVID thing is a little crazy, and but you know, through the magic of the internet and everything else, you know, we get to hear what you have to say, and some excellent comments and some really great points today. So thank you very much.
Well, thank you very much. I've really enjoyed being able to speak with you and to present to all of the people that will watch this in the future.
Yeah, that's excellent. Yeah, hang back. I'm just going to pull out. I'm just going to say a few closing words and go from there. So thank you very much. All right, everybody, that does it. Episode 16. That's our first one of 2021. I want to say thank you to all of you in the comments and people who are watching here. We will be back next week, Thursday at 2 p.m. I'll be making the announcement probably tonight or tomorrow on who the next speaker is going to be. So look for that on LinkedIn, or you can just go to the website and find it there. On that note, I want to say thank you to our speaker and looking forward to seeing you next week. Have a good one. Take care.